Judge Reeves comes to several conclusions, none of which are supportive of the actions of the U.S. Department of Education. First, Judge Reeves castigates the DOE for ignoring the concerns of parents, teachers, and students, along with their basic privacy and safety interests. It is an inescapable conclusion based on the foregoing discussion that the department has effectively ignored the concerns of parents, teachers, and students who believe that the final rule endangers basic privacy and safety interests, rather than address the evidence provided by the plaintiff states and others during the commenting period. The department throws its figurative hands in the air and says, "Too bad." But as the United States Court of Appeals for the Fifth Circuit has underscored, bare acknowledgement of possible issues a rule will create is no substitute for reasoned consideration, especially when the regulated subject is one of extraordinary consequence. The department has not identified significant evidence indicating that its motivations here are rooted more in sound considerations accounting for the serious privacy and safety interests than in the political preferences of an outcome-oriented rule. Based on this analysis, the final rule is arbitrary and capricious. Next, Judge Reeves points out how the DOE has far exceeded its statutory powers. Title IX of the Education Amendments of 1972 was intended to level the playing field between men and women in education. The statute tells us that no person shall be subjected to discrimination under any education, program, or activity receiving federal financial assistance on the basis of sex. However, the Department of Education seeks to derail deeply rooted law with a final rule that is set to go into effect August 1, 2024. At bottom, the department would turn Title IX on its head by redefining sex to include gender identity. But sex and gender identity do not mean the same thing. The department's interpretation conflicts with the plain language of Title IX and therefore exceeds its authority to promulgate regulations under that statute. Lastly, Judge Reeves points out that the rulemaking was arbitrary and capricious and devoid of reasoning. Additionally, the department's actions with respect to this rulemaking are arbitrary and capricious. The department fails to provide a reasoned explanation for departing from its long-standing interpretation regarding the meaning of sex and provided virtually no answers to many of the difficult questions that arose during the public comment phase. Notably, the department does not provide a sufficient explanation for leaving regulations in place that conflict with the new gender identity mandate, nor does it meaningfully respond to commentators' concerns regarding risks posed to students and faculty safety. All of this leads Judge Reeves to his final order. Based on the foregoing analysis and discussion, it is hereby ordered as follows. The motion for a preliminary injunction stay filed by Tennessee, Kentucky, Ohio, Indiana, Virginia, and West Virginia, and Christian Educators Association International and AC are granted. The United States Department of Education and Miguel Cardona, Secretary of the United States Department of Education, along with their secretaries, directors, administrators, and employees, are enjoined and restrained from implementing, enacting, enforcing, or taking any action in any manner to enforce the final rule, non-discrimination on the basis of sex in education programs or activities receiving federal funds and assistance, which is scheduled to take effect on August 1st, 2024. This injunction is limited to the plaintiff states of Tennessee, Kentucky, Ohio, Indiana, Virginia, and West Virginia, and extends to intervening plaintiffs, Christian Educators Association International, and AC in these 6 states. The preliminary injunction is filed, and the Department of Education is enjoined and restrained from putting their final rule into effect. Based on what I've read, this is a constitutionally sound decision. While some may not be happy, the fact that this injunction is limited to the plaintiff states actually comports with both legal standards and the Constitution. District judges issuing nationwide injunctions are the actual violation of their oath, since when Congress created these courts under Article 3, they limited them to a specific region. Also, under our Constitution, courts do not make laws. Based on that and basic legal standards, their decisions are limited to the parties to the case, which is exactly what Judge Reeves has done. It would not surprise me if the Biden administration appeals this case. I wonder if the circuit and possibly Supreme Courts will come to such a constitutionally sound conclusion as Judge Reeves has.